may proceed, Mr. Tangai. Yes, Mr. Impof, you may proceed.
Yes, God, Mrs. Malot. Malot, may I just start with a housekeeping matter? I had promised the court yesterday to hand up the bail application statement.
Yes,
I beg leave to hand up the copy up.
yes, you may. It will be exhibit.
Exhibit E, hello. And maybe just in fairness, although I'm not going to refer to it today, I'll give a copy to the witness
Yes.
because I read it out to her without her having this copy. Right. Thank you. Some kind of broad picture to try and do some shortcuts if we can. If we cooperate well, we'll have some shortcuts today instead of going through what I call the hard way. We'll find some middle way. I'm assuming that overnight you're still sticking to your guns that all these videos are proof of incitement.
Together, yes.
Yes.
In
Together.
context.
In other words, when you say together, what do you mean? Cumulatively.
Yes, so, my lord, for example, we went through this yesterday.
Yeah.
The text itself might not be incitement, but in the context of the video or picture, might not be specifically incitement. But if you look at the posts before and after as they go, you start to get the pattern.
Okay, I don't understand. I thought your evidence was that both looked at as individually and also cumulatively. Your evidence is that this amounted to incitement. In other words, if you look at them individually, we find incitement. But obviously, what you call the sum of the parts, if you look at them
Yes.
cumulatively. So is your evidence still that?
Yes.
Okay. All right.
Yes, my lord, in the context of.
Yeah. All right. Okay, well then, I'm afraid that means we have to go through the hard way. But what I'm not going to do is, because it's always tempting for counsel, when you, overnight, you almost go back to all the ground that was covered. So I'm not going to do that, as if you cooperate with me. And I just want to take you through that. You agree that, or at least you agreed yesterday, that looked at individually the tweet at 6.6.
Sorry, I don't have a.
Oh, you have your bundle. You know the witness bundle?
Well, we're just trying to locate the witness panel.
Yeah.
Lord, may I push the accused in the meantime?
Yes, Your Majesty.
It's like program will be long.
Well, can we have a short stand down? I seem to have mistaken the witness panel.
For how many
Maybe
minutes?
5 minutes or so, just so that we can locate.
For adjourn for 5 minutes.
Yes, let me just address my point.
But we get the court to just state them on paper now.
Thank you, Mr. Kangai. May proceed, Mr.
Thank you, my lord. I thought the state's case had collapsed, but looks like we're not there. Yes, thank you, my lord. One better to your lordship. Mr. Grant, I was just saying, and I want to go through this very quickly, if we can, just so that, as I say, we don't cover the same ground as yesterday. You and I have agreed that the tweet at 6.6, even if you look at the narrative and the poster standing alone, and I'm now dealing with an individual, please. Excuse me. So I know your qualification that in the context and so on. That's,
All right.
I'm just dealing with an individual.
Okay.
That tweet does not depict any violence, correct?
Correct, my lord.
And then at 6.8, we have the one about we are not fighting. Well, that's the most obvious one. We also agree that that doesn't depict any violence.
Correct, my lord. And like I maintain that, I know you said we're only dealing with the
Individual.
one. Like I said, I maintain that given the
No, the court
context.
has
I
noted
don't-
that. Believe me, you've said that many times.
Okay.
Yeah.
Thank you, my lord.
Yeah. And then the one at 6.10, that's the famous super spa one. We've now agreed that that doesn't depict violence.
Correct, my lord.
And then the one at 6.14, that's the traffic jam, quote unquote. We have agreed that that doesn't depict any violence.
Correct, my lord. Understand. Yeah.
Okay. Now, in that series, I hope this is going to be quick, but I just want to include in that 6.9. It's not, we didn't deal with it yesterday, but I think we can be quick. 6.9, you'll remember, is the one that says Mkababa, South Coast, we see you. And then there's the video is of a traffic convoy. I think that's what you call it.
Correct.
We accept that also individually doesn't constitute violence. Yeah.
Correct, my lord.
Okay, that's fine. Thank you. So that means 5 of the 15 we are at least on the same page.
Correct, my lord.
Thank you. All right, fine. Thank you. Now, before we deal with the rest, and again, I'm going to, as I say, I'm going to find some way to shortcut them so that we don't go through that. I just want to deal with a few, shall we say, principles. Remember, you are not like a normal witness. You told the court that you are legally trained, correct?
Correct, my lord.
And not only are you legally trained, one of your daily jobs is laying charges, so you know these things.
Correct, my lord.
Right. And remember I said to you, I'm not going to canvass to you much the issue of causation. Let me take a step back. In this court, it's my lord, I don't know if you have the pre-trial minutes.
Yes, I've seen that.
Yes. Okay. In this, you don't have to go there, but it's not in front of you. Let me put it that way. I just want to situate the case for you so that hopefully we'll work together. So the accused has told this court in the pre-trial minute that principally she admits that she sent the tweets. So that takes away a whole lot of evidence about metadata and all those things. Because that could have taken us days just to prove that the tweets came from her phone. But she said she would contest 3 things: causation, unlawfulness, and intention. You're familiar with this?
Yes, I am,
Yes.
my lord.
And I said the issue of causation we have dealt with general government.
Okay.
You and I yesterday we were dealing with unlawfulness.
Correct, my
We
lord.
remember the whole debate about freedom of expression and whether some incitement is allowable and so on. That was a discussion about
Correct,
unlawfulness. So unless if we can show that these videos firstly depict violence and then imminent violence, then they would fall under the exclusion in 16(2) of the Constitution.
Correct, my lord.
Yes. Now, and there's also another exclusion, quote unquote, and you can just take my word on this. You did say you hadn't read the EFF case.
Correct.
But I can just tell you that the EFF case established the fact that unlike in the old apartheid days, because we now live under the Constitution, which guarantees freedom of expression, the Section 17B of the Riotous Assemblies Act is unconstitutional to the extent that it outlaws any offense.
Okay.
Yes, and that it would now from now on be confined to serious offences, Schedule 1 offences and so on.
Okay.
Okay, so that's but we'll leave that for legal argument. Now, and you accept, because I don't want us to waste time, but if you and I establish that something does not depict violence, like these 5, then we don't have to go the next step of whether it's imminent violence. If there's no violence, there's no violence, imminent or otherwise.
Correct.
Thank you. All right. No, then thank you. On the same page. You have also agreed with what I said, and again, you have to trust me.
Okay.
I said to you, I know you said you didn't read Colonel Nazo's statement, but you've agreed that if I'm truthful in saying that Colonel Nazo built the case from your complaint on the basis that it is that she was acting in a common purpose in concert with others.
Okay.
And you said that was also your standpoint. You remember that? Okay,
Could you
let me
just remind
remind
me?
you. Yeah. I said to you, Colonel Nazo's statements show that he departed from the point of view that she was acting in concert with others. Then I put, was that also your understanding? And you said yes, yesterday.
Yesterday. Correct. However, it's not in my statement.
No, it's not. If it was in a statement, I wouldn't have referred you. That's why I had to go the roundabout way of starting with Colonel Nazo.
All right.
So
Yes.
I accept it's not in the statement.
As someone that hasn't seen the investigation, my lord, it seems on the face of it, I agree. Yes.
Yes, no. Please listen carefully. I don't want you mustn't answer for Colonel Nazo. I was giving you that just as a reference point.
Okay.
You answer just for yourself.
Okay.
I'm just saying, in reference to that, you also are of that view that she should have been acting as part of, in concert with others.
Correct, my lord.
Yes, thank you. No, Colonel Nazo will answer for himself.
Thank you.
Okay. And you've had the prosecutor many times indicating to the court that that approach of yours and Colonel Nazo has now been abandoned, or at least he says his case is now not about common purpose or conspiracy. You've heard that.
Can you just refresh my memory when that?
Okay, you may not have been here. From day one until yesterday, the prosecutor many times has stood up and told the court that his case has got nothing to do with common purpose. I think once when you were testifying, and that it has nothing to do with conspiracy.
Okay.
Either you accept my word or...
I accept your word.
You don't remember that?
I don't.
Okay,
remember.
that's fine, fair enough.
Apologies, my lord.
No, I don't think it will be changed. Okay, so something must have happened then to change the nature of the case. All right. You also testified yesterday that you obviously cannot dispute the evidence of General Governor that there was no direct link between the accused and any looters. In other words, her target audience were her followers, obviously.
Did you ask if I agree or
No, you
sorry.
confirm that you can't dispute if that is the evidence of the investigators.
I can't dispute that the accused, that the looters were followers of...
No, that you were not. Okay, no, I said, okay, it's fine, I understand. I put to you that General Governor had considered that there was no direct link between the accused and the looters. He, however, in fairness, I said to you, he did say that some of the followers might have been participants in the WhatsApp groups and what have you.
All right.
But that there was no link between her and the looters. You can't dispute that.
I can't dispute that, no, my lord.
And there's nothing in your evidence that would suggest that her messages reached the looters?
No, my lord.
Yes. And to the extent that it might have eventually reached the looters, it would have been via the, what we call the persons of interest. In other words, the chain of causation would be broken somewhere.
Correct. I don't know the chain of
Yes. Anyway, that's
correct.
fair enough.
Correct, my lord.
Right. Now, okay, so that's the whole causation thing. So coming to unlawfulness, we've already covered 16.2. Cover this. Cover this. Yeah. So that then, and those three clusters of differences leaves us with the question of intention. Okay? That's where I want us to start today. Now, if you pick up any of these different, I don't want to call them counts, because you correctly said this is not a statement from the prosecutor, it's just your statement. So let's call them complaints.
Correct, my lord.
Yeah, to use a neutral word. So in your 15 complaints, let's just take the first one, just as illustrative, because they all are the same, except for the content of the message and the video. They are all the same, framed in the same words, correct?
Correct, my lord.
And those words are, in that on such and such a date or time, depending on the message, at a place between unknown Duduzile Zuma-Sambudla unlawfully and intentionally published words on her Twitter account, explained, words likely to persuade, provoke, or urge persons to violence or producing imminent criminal offences and likely to incite or produce such action. And then it's the wording, for the purpose of getting her father, Jacob Zuma, out of prison. They're all like that, except obviously the message and the video. Is
Correct,
different.
my lord.
Yes, okay. So we don't have to go to all 15 of them, all are like this.
Correct, my lord.
Okay. Now let's look at that particular one then, just for illustrative purposes. I just want to pick out the framing of this. You agree that all of them, in all the messages, if it was a song, we would call it the chorus, the refrain, I think is a better word there, is for the purposes of getting her father, Jacob Zuma, out of prison.
Correct, my lord.
So we all agree that her main intent, her main purpose was to get her father out of prison.
Correct, my lord.
And to the extent that of the let's call it the big five, to the extent that she used tweets that do not depict any violence, she still had the purpose of getting her father out of prison, right?
Correct, on an individual.
On each, yes. Right. And I'm sure you will agree, just as a person or a daughter, I don't know, but that it's understandable that a daughter would want her father to be out of prison.
Yes, my lord.
And that distinguishes her from all of us, all the other 50 million, because her standpoint is that this is my father and I want him home. Other people might have political and other motives, but just at a human level, we understand that.
As a daughter wanting her father, correct, my lord.
Yes, okay. And that was her main objective.
Correct, my lord.
Right. Right. Now, that being the case, we then can narrow this thing down to looking at the rest of of the before we do that, let me say this, and please listen carefully to this question. And if you don't understand it, I'll repeat it. But it's quite important. Do you accept that if the court looks at these tweets individually, you remember I said both individually and cumulatively. So let's put cumulatively aside for now. If the court looks at them individually, then the court will have to assess them as they stand.
Correct, my lord.
Similarly, if the court looks at them collectively, the famous bag of potatoes, if they look at them cumulatively and it turns out that the majority of the potatoes are rotten, then the court it will be doubtful that anything will come out of it. Let me put it that way. I don't want to put it higher than that. In other words, if the contamination is such that the majority of them are non-insightful, then it's doubtful that any of them are insightful as a collective.
Correct, in that weighing it up.
Yes. Thank you.
Weighing it up and determining.
Yes. Thank you very much.
Correct.
Especially in a criminal matter, because we are talking about reasonable doubt.
Correct, my lord.
Okay, thank you. No, that's fine. So now then, let's go through the exercise. Sorry, maybe the last question is, obviously, if we can show that all 15 do not incite violence, then we don't even have to do the cumulative exercise. Because if all 15 of them are rotten in the bag, then clearly the bag is rotten.
My lord,
if you follow what I'm saying.
I understand.
Sorry, just to explain it. In other words, if all, and the emphasis is on the word all, if all of them are not, do not amount to incitement, it doesn't matter, even if there are 100 or 1,000 or 20,000, but if all of them do not amount to incitement, then collectively they don't.
My lord, I disagree with that.
Okay.
Because it is up to the court to determine what that, cumulatively, what the message shows.
Yes. No. I accept that. I accept that. Sorry, maybe let me rephrase the question. I'm saying, just as a matter of logic, you are right that the court will have to do the assessment. But can you envisage a situation where the court says, all of these things do not amount to violence. All of them are about peace and prayer. But when you look at them collectively, they amount to violence. That's just not possible, is it?
If each individual one was about peace and prayer, correct?
Yes.
Correct, my lord. I understand what you're saying.
Okay.
I understand what you're saying. But correct. But
Yes.
I can't state what the court is going to find.
You can't give judgment, please. There's only one person in this room.
I don't want to say something where I am giving a judgment on that. I've just got my allegations, and it is up to the prosecution to deal with that to the judge.
No, yours is just to answer truthfully.
Thank you.
What the learned judge and the prosecutor and me make of it, we will argue at the end. So.
Thank you, my lord.
My lord, I noticed that my colleague and the witness often end up talking at the same time. And that's going to create a problem with the record, and I would appreciate if they spoke one at a time. Otherwise, we're going to have to end up reconstructing this record if it becomes in the...
Thank you, Mr. Ngai. I will watch. I'm sure Mr. Mpofu also have heard what you have said.
Thank you. I'm indebted to my learned friend, and I'll take responsibility of being the one who will allow the witness to talk when that situation, if and when it arises. Thank you. Okay, ma'am. Sorry, I've lost my train of thought here, but that's fine. I think we have agreed that subject to the qualification that you can't pass judgment, but you would agree that that statement at a logical level, that 0 times 10 or 0 times 100 is still 0, correct?
I disagree on that, but
Okay.
it's my personal, not as an expert who has analysed each one
No,
individually.
No, I'm not
I
even
feel-
going. I'm sorry,
yeah.
sorry, ma'am. You
No,
can
just
go
a
on.
moment, just a
Carry on.
moment, Mr. Go. I'm sure you are eager to move. Just give her to
Yes,
finish.
yes, that's what that's why I'm
Yes.
apologizing, ma'am.
Yes.
Thank you.
let's
Sorry, you
listen
can
to
finish,
you.
Ms. Trent?
You say you disagree. What do you disagree
That-
with, and then expand.
If each individual post is not inciting violence, that cumulatively it can't be seen as inciting violence. Am I correct in that?
I think that arises from if all posts cumulatively constitute violence. But then
Sorry,
if you
my lord, I
start
can't hear you.
counting, sorry,
I can't hear you clearly.
the council is saying, if you say all posts are cumulatively constitute violence, then his next step is if you count all of them and you find that each of them one by one does not constitute incitement, would you still say that cumulatively they constitute incitement? I think that is
Thank you,
right.
my lord. 100%, my lord. I can't even add to that. That's 100% what. In other words, the emphasis, I even said to you, the emphasis is on the word all, as the learned judge said. If all of them, each one, in other words, does not constitute incitement, then it can be that when we put them, all the zeros together, suddenly there will be violence.
My lord, when I think about in this case, these are examples. It's not the full, all the tweets. I believe that cumulatively they do show incitement, whether the individual post might not, but I do.
So, Ms. Trent, so that we shorten what might keep us long here. At this stage, we haven't made a finding whether each of them, except the 5 that we have already considered out of 15, but we haven't reached a stage where we say each of them, the rest, constitute incitement or not. We haven't reached the stage. The question is hypothetical question.
That sense.
That in the event, you'll say, Mr. Kanga, if I'm wrong, it's hypothetical that in the event, all of them one by one does not constitute incitement, would you still say these posts cumulatively constitute incitement or not?
That's a good.
My lord, it's quite. I can't. In this case, it depends. For me, some of the photos and videos show weapons or burning and that kind of thing. Whereas I understand that I keep saying cumulatively and everything. There's a different. Hypothetically, I don't know whether I can answer that.
Okay. Let me, I'll try, because I don't want to accuse you when I'm arguing of evading this question, because it's a simple question. So I must be fair to you. Let me assure you that the court is aware of your stance. I've asked you, like yesterday, I asked you today. Your stance is that these posts amount to incitement. So nobody is interfering with that. Okay? Yeah. So just to assure you. So we're not tricking you. All I'm saying is, if you are wrong, if in the end, and that's why the learned judge says it's speculative, because once a thing starts with if, already.
Hypothetical, it's
Yes,
a tricky
If,
one to
yeah,
answer.
if despite your insistence, despite your great evidence, it is found that all of them are not violent, you would agree that putting them together cannot improve the situation.
I would disagree.
You disagree? Okay, fine. I'll leave it at that. I'm just going to leave it at saying I'm going to argue that it's self-evident. Firstly, I'm going to argue that you are evading the question. I'm also going to argue that it's self-evident that if you put 10, 20, 10,000 zeros in one bag, the effect is going to be zero.
Okay.
That's what I'm going to argue, but let's
All right.
move on. Okay. Now, you have never suggested, have you, as the person who is the, shall we say, to use a biblical term, the alpha and omega of what brings us here. You have never suggested that the accused did anything approximating or close to terrorism. That's not your case.
Correct,
Yes.
my lord.
We'll find out where that case came from. Yours was about, I think, public violence, that she incited public violence, and I think malicious injury to property.
Correct, my lord.
And in your evidence, you've referred mainly to public violence, correct?
Correct, my lord.
And again, you don't have to answer this because I'm just taking advantage of the fact that you're legally trained, but you don't have to answer. Would you agree that there's an amount of, shall we call it, splitting of the charges? So there's public violence, they dropped your malicious intention to property, for whatever reason, we must go there. But then there's public violence, common law, public violence, statutory, and this terrorism thing. But the reality is that there's one accusation that she incited people to commit violence, public violence. Correct?
Sorry, I thought you said I don't have to.
No, you know, I'm saying you don't have if you are uncomfortable because it's like a legal question.
Oh yeah, no, I don't know.
You have no comment.
I don't.
Okay.
I have no comment, my lord.
That's fine. All
I
right.
think
We'll leave that to argument.
in terms of splitting the charges, I think that would be an argument that I.
Yes.
Yeah,
Perhaps in simple language, it's what in your studies you might have said, actus reus,
Yeah.
that it all arise from the same facts.
The same
So-
act.
Oh yes, yes, of course.
Yes.
Yeah,
Thank you.
yeah.
Thank you, Madam.
Sorry, my lord.
Yeah. No, that's fine. And again, with both His Lordship and me, I asked you that question because of your training. If there was another witness, they wouldn't even know what actus reus means. Thank you. Okay. All right. Okay, let's move on then. And again, this is. I want to hold it against you. Are you familiar with the concept of in incitement law, with the concept of concretization? If you are not, I'll explain what it is.
I'm not, my lord.
You're not, okay. And simple, and my His Lordship Judge Matento will simplify it if I'm putting it in a complicated way. Okay, it basically, to simplify it, it says that you can't just say, no, my lord, can I just refer to a better authority than me? This one belongs, believe me. You are familiar with what we call the Bible of Criminal Law, Sneyman.
Yes, my lord.
Okay, Sneyman says at page 300, and my lord, I'm reading from, I think it's the 5th edition of Sneyman. under incitement. It says the concretization requirement. Okay? And it says, in order to commit incitement, X's words, which he addresses to Y, should not be too vague or equivocal. They must sufficiently be concrete or specific so that Y will know what she is incited to do. You follow? So,
I follow, yes.
yes. An extreme example of inciting words which are too widely formulated to amount to punishable incitement is when X says to Y, commit crimes. Such a statement cannot qualify as incitement because Y does not know which crimes she is spared to commit or who or what should be the object of a criminal offense. Okay?
My Lord, I reached a point where I must object now.
Oh, yes.
What my colleague is doing is entering into, or it sounds like he's entering into a legal discussion with the witness whose only concern was these tweets sound to me like they are inciting, and she alerted the police to it. That was her role in these proceedings. All the legal decisions that were made by us, the prosecution. We can argue about that at some point. This witness has not informed our legal decision at all. Her job and her role in these proceedings was to alert the state to the fact that there is a person making or posting tweets that concern me that they might be inciting. That is the level of her involvement in this matter. The fact that she's not brought here as an expert of any sort, she's been brought here as the complainant in this matter. I have no problem with the questions my colleague is asking, but when it starts to, when we reach the point where we are trying to extract opinions on legal definition, or if I wanted to, I would have called this witness an expert, and I have not done so. And I think that it is unfair for this witness to be questioned on issues that he has said she has no expertise in. She's
Yes,
an non-practicing attorney. It is unfair to do so to her.
I think, Mr. Nkosi, Mr. Mpofu, you can move forward because
Yes.
whether the witness understands those legal terms or not, it will not make any difference. But I understand that we are asking her because of her knowledge and from what she has stated
Yes.
in her statement about lawfulness and
Thank
so
you, my Lord. That's all. My Lord, I'm not going to press the issue much. My learned friend obviously knows that once I've put this thing, I'm going to ask the witness whether she understands. If she says she doesn't understand, we'll move on. But the most important thing is what your Lordship has said. My learned friend is not being fair to the court. Unlike most witnesses, if it was General Govender, I wouldn't be posing these questions. Your Lordship has pointed that this is a witness. It's not true. It's specifically not true that all this witness has come to say is that I was concerned about tweets and I went to the police station. That is false. This witness has come to this court with a statement that says this was unlawful, intentional, for the purposes of Section 16 of the Constitution says this and that and that. So why would I engage with a normal witness at this level if she did not voluntarily put a statement of that nature? So we are entitled to find out what did she mean when she wrote intentional. But I will change the question, but I just don't want the court to
Thank
be,
you. You may
to be
proceed.
misled.
My Lord, I don't know if I'm expected to reply to that.
Yes. You may sit
No, I
down.
was replying.
You may sit down, Mr. Mpofu. Let's hear. Yes, Mr.
My Lord, this witness has been brought as a complainant in this matter. We clearly stated she is not being brought as an expert. She herself says, I have a legal qualification, but I don't practice as a lawyer. I'm a non-practicing lawyer. Right? To engage in legal arguments with this witness is not proper. It is not fair to the witness.
Yes, Mr. Kangai, I've already ruled on that. I've already ruled and say yes, alluding to that only as far as the witness have herself stated it's unlawful, but without debating law with the witness. Because the issue of law will come during address, not now.
Indeed, my Lord, and I accepted that ruling, but it is the address that my colleague made after your ruling. Either he was going to pursue it or oppose my application.
Well,
It sounded
people
like he was
have got
opposing it.
different arts of speaking and narrating issues. What he was explaining thereafter, my ruling stand that
Right.
this,
So,
my ruling stand that for now we don't debate law.
indeed, my Lord, if it is that he was explaining something, that's fine. If he was opposing my application, then I was entitled to this right of reply.
Thank
But
you.
now that your Lordship has made a
Thank you.
ruling,
Can we now
yes,
proceed?
yes.
Thank you, Lord. As I said, my opening words were, I will move on to something else. But maybe Malana friend didn't catch that part. Okay. Now, all right, let's forget about the concepts. It is not your case that, let's take any of the posts, the ones that are not, let's say the one about the traffic jam. So it is not your case that those posts were inciting a particular offense. In other words, you're not saying, she was not saying, I'm inciting you to cause a traffic jam. That's not your case.
That specific post, correct?
Yes.
Correct, my lord.
All right. Fine, that's fine. That's sufficient for the purposes of, and in fact, in respect of each of those posts, except the two that we'll deal with at the end, which is the one of the gun shooting and the other one of the Moi Plaza. Put those aside. In all these other posts, it cannot be said that there's a specific offense that you must do this, you must loot, you must do X. There's no concrete offense that you were saying that she was inciting, except for the general unrest.
Correct. She did not say loot or
Yes,
you must go and loot.
Yes.
Those are not words that she
Thank you.
stated.
That's fine. That covers my question on the concretization. Right. Thank you. Now, I keep on promising that now we're going
keep
to,
thinking
to
you're
the
finished.
post. Yeah. No, we are going to go to the post. Well, it was all up to you. We could have been finished now. But you said, no, you still have the other 10 posts. Let me do this again in the interest of speeding it up. You accept that, let's go to 6.1 to 6.4. Because I want to now get rid of these things in groups. So 6.1 to 6.4, if you look at the times, okay, so then I'll ask you a question. It might sound like a stupid question, but you'll see where I'm going with this later. You accept, don't you, that my client, Ms. Zuma-Sambudla, could not have been doing something to get her father out of prison if he was not in prison?
Correct, my lord.
Thank you. Okay. Thanks. That was painless. Okay. Now you accept that in terms of the posts at 6.1 to 6.4, in respect of all of them, you said she did whatever she did for the purpose of getting her father, Jacob Zuma, out of prison. But up to 6.4, he was not in prison. Do you accept that? Okay, now let me assist you. Let me assist you, ma'am. Do you accept that the evidence, or everyone knows in the country, that former President Jacob Zuma handed himself into incarceration at around midnight on the 7th, between 7th and 8th of July?
Correct, ma'am.
Okay, fine. Now, do you accept that those 4 posts, all of them, are before that time?
Correct, my lord.
And therefore, they could not have been to get someone out of prison who was already out of prison.
My Lord, he, if I'm not mistaken, he had been found guilty.
On the 29th of June. Yes, but that's not what we're talking about. We're talking about prison.
Physically in prison, correct? Correct.
Correct
Okay.
what?
He was not in prison at that time.
And therefore-
Sorry, the answer to that.
Okay, so
Correct.
and therefore it's impossible that she was doing anything to get him out of prison because he was already out of prison. Correct?
Correct.
Thanks. Okay, fine. So that takes care of those 4 posts. Right. Then let's go to the famous "We See You" posts. And that group also, I think it's going to be quite easy. Let's start at 6.7.
7.
6.7.
Hey,
yes,
kungcono
ma'am.
ngikhuluma isiZulu namhlanje madoda. Kungcono impela ake ngikhulume isiZulu ngoba isingisi akuzwakalanga izolo. Asikhulume nkantolo. Senizosiphoqa-ke manje ukuthi i-court order ngicela ukuthi ikhiphele umuntu ngaphandle. Ngiyazi lokho akurekhodi ngoba isiZulu akusizwe. Kodwa ngenzela ukuthi nizwe kahle ngicele kahle kuthangi nayizolo. All what I'm saying is that now in our vernacular language I request them to adhere to the decorum of the court and not talk and do other unwarranted issues in court. Thank you. You may
Thank you, my
proceed,
lord.
Mr.
Thank
Boss.
you, my lord. All right, let's do this quickly as well. We said what, 6.9?
Yeah, I think 6.7. You
Oh, I said 6.7, yes, let's do 6.7 quickly. That one is, it simply says, Richards Bay, we see you, that's all.
correct, my
Okay.
Lord, with the writing in brackets.
Yeah, in the record.
Yes.
Yeah,
Yes, my lord.
who does the sugar cane that is being burnt to belong to? You would accept at least, I'm sure, that a question cannot incite violence.
Correct, my Lord.
Yes. And that's the...
So you are, when you say correct, you accept this does not constitute
The
violence.
words itself,
Yes.
the specific words
Yeah.
alone. Correct, my Lord.
Thank you. May proceed.
Thank you very much. So, okay, so let's move from the words. And as far as the video, and correct me if I'm wrong, I thought you said you cannot remember what that video depicts.
It seems to be burning sugar cane, but I can't say exactly, my Lord, what it is.
No, but your lordship
Sorry,
asked you.
yeah, correct.
No, I'm sorry. His lordship asked you yesterday specifically, is there any sugar cane that you can see burning? And you said no.
Okay, sorry.
You accept that?
I accept that, yes, my Lord.
Yes. The only thing was some voiceover.
Correct, my Lord.
Yes.
Thank you for
Yes.
refreshing my memory.
Thank you, no problem. And by the way, the person in the voiceover just said cane was being burned. You remember that? There's nothing about sugar. So do you want us to play it again?
I can't recall whether he said sugar or just cane.
Well, I can. Unless if we can ask, I think that would be 6.7. Sorry, 6.7 is D15. D15 is a short.
Counsel, unfortunately, I'll be now forced to instruct the court orderly to remove somebody who's playing, whether he's playing music at the back there or not.
It's good, Mrs. Mother. Please, whoever it is, please leave. We can debate outside.
Or is the police officer?
Thank you. Thank you, Madam.
Thank you, may proceed.
Thank you, Madam. Yes, I will ready. Thanks.
This is the situation at the roadblocks at Tangawizi and Meadowmead. They've blocked the entire road with trucks, both sides. They've started to burn the cane. By the looks of it, also burning at the N2, block the N2. So John Ross is a no-go zone. Don't even attempt to come this way.
Okay.
Yes, I
So you accept that, firstly, there's no sugar cane or any cane that we can see.
correct, my lord.
And you accept that even the voiceover talks about cane. It doesn't say what kind of cane.
Correct, my lord.
And there are many kinds of cane.
Correct, my lord.
Yes. The only, as my learned friend pointed out to you, the only reference to sugar cane seems to be that the accused assumed, as, like you, that they were talking about sugar cane. And she says, who does the sugar cane that is being banned belong to?
Correct, my lord.
Yes. But we've already established that that is not violence. Correct?
On its own, correct.
Yes. So we can tick 6.7. Both the narrative and what we saw on the video does not depict any violence. Correct?
Correct, my lord.
Thank you. Then let's go to 6.11.
6.11.
11, yes ma'am. Okay, I'm not going to ask you again that the words Lady Smith, we see you do not depict violence. I won't ask you that. So let's just go straight to the video. You and I have established that the words we see you do not depict violence, correct?
Correct, my lord.
Yes. All right. Now there, the video is it's D23, yeah. And I want maybe it's a short one as well. We can refresh your memory, but if you still remember it, we don't have to waste the court's time. Would you agree that there all we have is really just people standing and some smoke, and I'm prepared to assume that you are correct, although I didn't see it myself, that there were tires burning on the road. I think that's how you gave the evidence.
Correct, my lord.
That's yes. And you'd accept that even if the tires burning on the road, the burning of tires on the road in South Africa is an usual occasion. It's not a serious offense, correct?
I don't know, my lord.
You don't know.
If whether it's a serious.
Well, just in your view.
I think it is maybe an offence.
Yeah, let's say
Blocking the road,
Yes.
burning.
Yeah,
on
sounds
a
allowed,
road.
make no mistake. But I'm saying you wouldn't say that's a serious
Oh,
offense.
in terms of incitement.
Yes.
Correct.
No, okay. Thank you. All right, then let's go to 6.12. Okay, well, 6.12 is an easy one. Firstly, it says, somewhere in SA, Flames of Freedom, we see you. That's obviously not violent, correct?
Correct, my lord.
And then the video shows burning behind some hill. We don't know what's burning.
Correct, my lord.
And you admit that that is not violence.
Correct, my lord.
Thanks. So let's go to 6.13. Again, I won't go into Zuma, we see you. I won't waste the court's time with that. But the video, again, I don't think this video was played, but you said you can't remember what is in that video, correct?
Correct.
Okay, so then that doesn't count. Okay. Now, thank you. So we've now covered all the videos except the two that I'm going to deal with now quickly, because these ones, and you must listen again carefully. For current purposes, can assume that in general, I accept as any law is an offense.
Correct.
Assuming, of course, that the gun that is being fired is not licensed. Correct? But in this case, we don't know whether the guns are licensed or not licensed. Correct?
Correct, my lord.
Objection, my lord, that is an incorrect submission. The firing of a gun in certain circumstances, whether licensed or not, is a criminal offense.
I'm coming to that. Thank you. Okay, so I've just been disturbed unnecessarily. You accept that the starting point is that whatever the circumstances, if the gun is unlicensed, that's obviously an offense.
Correct.
Okay, that's all I was saying. Yes. And then secondly, as the famous case that just finished, even if the gun is licensed, if you fire it in a stadium or a crowd, that is an offense.
Correct.
Okay. Okay. Now, and here we don't know where this was being fired into.
Correct.
Yes. Right. Now, and I'm interested, and this is just for my own interest. You said that at the top of 6 points, the screenshots of the video posted above 2 men shooting off the 3 guns. How did you know they were men?
Sorry, wait.
At the top of A2-3, typed page 3 of 15.
Okay.
At the top, yeah, you say screenshots of, are we together?
Yes.
Yeah, screenshots of video posted about 2 men shooting off 3 guns. How did you know they were men?
I do not know.
You don't know?
My lord.
Okay. So you were assuming?
Yes, my lord, I was assuming.
All right. And therefore, whether that is an offense or not offense depends on all these things that we've discussed. Licensed, unlicensed, is it in a crowded space, a dangerous space, and you don't know the answer to that, correct?
Correct.
Thank you. All right. Then the last one that is left then is 6.4. Moi Plaza. It was played yesterday, so we won't play it again. Again, we agree that on its own, Moi Plaza, we see you does not denote violence, correct?
Correct, my lord.
We've also agreed that to the extent that the date was missing there, but your confirmation was that the date was the 5th of July 2021.
Correct.
We also have agreed that that could not be for the purposes of getting a father out of prison, correct?
Correct.
And so whatever was happening at Moi Plaza, let me put it this way, we don't know actually what that incident is about.
Correct, my lord.
Yes. Then again it goes back to this thing of doubt. It might be what you think it is or what I might think it is, but the reality is that we don't know.
Correct. Correct, my lord.
It could be anything, correct?
Correct. Yeah.
Yeah, could be just somebody,
I think we've covered what different people's interpretation of what it looks like.
Absolutely.
But
yes, well, what it
for
may
your
look
question,
like.
I think we've covered
You
that.
don't know yourself. Yeah.
Yes.
Could have been a best tank
Yes, but
with petrol.
taken as a whole again. I know I've said this, we've covered that taken as a whole and how someone depicts it.
No, no, sorry, I don't want to be unfair to you. All I'm saying is that maybe let me put it as at the lowest. It's possible, isn't it? Because you don't know. Once you say you don't know, you don't know.
Yeah.
So it's possible that it could have just been a best petrol tank.
Oh, sorry, I didn't understand your question or didn't hear it properly. Correct.
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 All right.
I didn't hear when you said burst tank.
Yeah,
I
that's
didn't hear
it.
that.
Sorry, maybe it's
Okay.
a bunch of education.
Apologies, my lord.
All right. So, in all, then we've covered all the. Just want to make sure. Yes. Sorry. There's one. Oh, okay. There's just one category which is interesting. 6 points. And again, I'll do this as quickly as possible. Your evidence, you remember, was that it's sometimes it's the wedding coupled with the video. I mean, mostly, correct?
Correct.
Yes. So obviously, then, when it comes to, let's go to 6.2. All right.
Yeah.
6.2 is just the wedding, comrades, Yabonga, and so on and so on. My way Africa, but there's no video. Or rather, there's just people. There's no violence or anything approximating violence, correct?
Correct. It says, you did this, Lebonga, let us now organize ourselves and unite to take back our land,
Yeah.
take back our country from the WMC and their proxies in leadership positions. Correct. Correct.
And we can take back our land from WMC without violence, correct? Hopefully.
We can't take our
Land.
sorry, what is the question?
I'm saying we can take our land back from WMC without necessarily using violence.
Can.
Yes,
Correct.
thank you.
Correct.
And then 6.3, there's no video. So for it to be insightful, it would only have to be the words, because there's just a picture of former President Zuma.
Yes, Mr. Kangai, stand in.
I'm sorry.
Yes, Mr. Kangai.
I'm sorry that I see objections, but my colleague doesn't see me. Normally he would see me.
No, I'm sorry.
Right. It is not true that there is no video. The video is amongst the 32 videos that are on Exhibit B.
Okay.
And
That was 6 point.
it's video 12 on Exhibit B.
Video 12.
Yeah, the one that you referred to now for 6.2 is video 12 on Exhibit B.
Okay. All right. Look, is it long?
I didn't play it, so I can't remember.
It was not played. Okay. I think okay. Let me just say, from what we see, from what the court has in front of it, because if it wasn't played, it wasn't played. That's a problem of the prosecution. From what we can see here, the only picture we have is a picture of former President Zuma. Correct?
Yes, the profile.
Yes. Thank you. So that's fine. But we can't make the case of the prosecution. Yes.
Mr.
Well,
Kangai, I don't know, both of you are talking.
6.3,
Yes.
the one where there's a crowd of people.
Yeah.
My colleague put to the witness that there was no video, and I corrected him to say there is a video of that. I didn't realize that in the meantime, while I was looking for it, we had moved on to 6.4.
All
Sorry,
right.
6.2 there's a video of.
All right.
6.3 there's no video of.
Thank you. All right. So,
Thank you.
thank you. So now we're on the same page. There's no video there at 6.3, correct?
Correct, mother.
And the wedding we've already dealt with. 6.6, there's no video. We covered that yesterday. That's the shutdown one.
Correct, mother.
Okay. And
That was 6.6.
6 ballots. And 6.15, which is the only one we haven't dealt with. There's no video there, correct? It's the one.
Correct, my lord.
Yes, it only says Black South Africans, the economy that our ANC proxy leadership under WMC is telling us about does not belong to us. Do you own a mine? Do you own a bank? Do you own land? Do you own media? Do you own ports? Even the food supply is owned by WMC, by Buye Africa, Amanda. Nothing violent
Correct, my lord.
and no video.
Correct, my lord.
All right, now then I think we've covered all my work. Now, before, I just want to I don't want to, as they say, flog a dead horse, but for what it's worth, my lord, I beg you to hand up. This will be quick, my lord. It's just a copy of this is.
Thank you.
This will be very quick. It's just for your education. So you don't know what a shutdown is. All right. What I've handed, that will be F, my lord. I think F. I've handed you a poster of some event that's supposed to be happening next Monday. It's called the National Shutdown, 17 November 2025 at 8. Hashtag arrest corrupt officials, hashtag R7 to the dollar, or whatever, and then rent manipulation, and it's supported by Women for Change and Women's Shutdown. Would you agree that that does not, asking for a shutdown does not call for violence?
Correct, my lord, but we don't know what's going to happen.
No, of course. No, I'm just saying at the level of calling for it.
Calling
So in other words, if I support this, or I say I agree with this, it doesn't mean I'm inciting violence.
Correct, my lord.
Yes. Because remember, that's what the post said at 6.6. I agree with this amount.
Correct, my lord, but we don't know what's going to happen, and
No, absolutely.
Yeah.
Even if you can
but
plan,
on its own,
yeah.
I agree
So
with you.
again, you are talking simultaneously. I think both of you, because even yourself as a witness, you don't give yourself time. What were you saying? Can we hear you? You say correct. What is correct?
That this in itself
Yes.
does not incite violence,
Yes. That is the end of your answer.
but we don't know what's going to happen on this day.
Yes.
That's
I agree. Thank you, Madam. Now, Ms. Trent, as a now admitted attorney, I want you to listen to me carefully. Who drafted this statement for you?
I drafted.
Everything.
So how it happens is I draft it, and someone in the office will go through it, comment, and the final draft will then be done by myself.
You didn't take it to some other legally trained person?
No.
No? Where did you draft it?
I think I was working at home that day,
Where is home?
in Stanton.
Okay. And why did you not disclose to the court that I suppose that's the prosecutor, but you can answer the question anyway. You are prepared to disclose to the court that you did 2 other statements,
Correct, no.
and you don't know why those statements were not given to the court?
I don't know, madam.
Yes. All right. And one of those statements that you made has an important point, which the court is entitled to know. And let me just take you one step back, ma'am. I'll try and summarize this. You remember your evidence is that the genesis of this, I said it was you, it was not. The genesis of this whole thing was Mr. O'Sullivan, who then transmitted it to you, correct?
Yes, correct.
Yes.
Correct.
Yes.
Forensics for justice,
Forensics
myself
for
and
justice.
him.
Yes,
Correct.
relatively. All right. Now, but you, as a citizen of South Africa, you describe yourself as a concerned citizen. You were acting on your own.
Correct.
You were not acting with, not with common purpose. You were not acting in concert with anyone.
When you say concert,
No, I mean, you were not acting as a representative. You were just a concerned citizen who went to the police station, as my learned friend has said, and laid a complaint, like all of us.
Correct, and described myself that it was through Forensics for Justice.
Yes.
Correct, which was myself and Paul O'Sullivan.
Sorry?
Myself and Paul O'Sullivan, which is from Forensics for Justice.
So who is the complainant? Is it
Myself. Myself.
you on behalf of anybody or just on behalf of yourself?
Myself.
Just yourself.
I don't understand the question.
But why didn't you answer the question if you don't understand?
So, I opened the case
I know.
in my name. Yes,
Ma'am?
correct.
Okay, let me simplify this. I can go to the police station now,
Yes.
right? And I say, I myself, I saw you stealing somebody's, or I can go for the legal team. Which one was it? Did you go on your own, or were you going as part of, as a delegate of some collective?
As a delegate of Forensics for Justice.
Ah,
I don't,
in other words, you were there representing yourself and Mr. Sullivan and the NGO.
the NGO, yes.
I see. So the complainant is the real complainant is the NGO.
It's myself. I describe myself and I describe Forensics for Justice.
All right. So if you go to,
Perhaps we may just need clarity. I think the issue is whether you open this complaint in a representative capacity, for forensic justice, or you open the complaint as a concerned citizen yourself. That's what the council is trying to find out.
thank you, ma'am. I'm going to get to the point. You understand?
I do.
It's very simple. You do something in an individual capacity or in a representative capacity. Which one was it?
I don't think it's necessarily a representative. Forensics for Justice opened the case. I opened the case as part of Forensics for Justice, who decided that we would open it. So I guess you could say representative capacity.
You guess. And I'm asking you that question because if you go to paragraph 7 of your statement,
Sorry, Council, before you proceed.
thank you, Madam.
I think this question arises from your previous evidence that you assist people to even lay charges, that is your NPO. So it arises from that. So if you assist people in the forensic justice to lay complaint, then you'll be assisting those people. But if it's you, just yourself as an individual, who lay complaint, whether you are working for that forensic justice or not, it will be just your own complaint. Do you understand
I
that?
understand. If I can just clarify, there's Paul O'Sullivan and Associates, where we have clients who come to us, and that's when we assist in opening the case. In Forensics for Justice, if we see something and we think we should open a case, then we'll open a case. In this instance, I drafted the case, I signed it, and we opened the case, Forensics for Justice.
We opened the case. Okay.
Yeah, the case was opened based on my statement.
Yeah,
I don't see.
I'm saying, is it we or I who opened the case?
When you say open the case, opening the case is by making the statement.
Yes, the full statement.
Correct.
So, for example, when you were calling for the accused person to be arrested, was it you, Ms. Trent, or was it, what is it called? Forensic for Justice? making that call?
Forensics for Justice.
First Forensics for Justice.
And myself.
And you. Okay. All right. No, that's fine. And Forensic for Justice, do you receive any foreign funding?
Foreign funding?
Yes.
Not that I'm aware of.
Are you involved in the fundraising, or is it just Mr. Sullivan?
We don't do fundraising, no.
How do you survive?
Paul O'Sullivan pays for any expenses.
Yes.
Expenses, the employees of Paul O'Sullivan and Associates will do the work. And if there are expenses that need to be paid, then we cover that.
That's fine.
But I don't know about foreign.
No, that's fine. So you don't know whether Paul O'Sullivan raises foreign funding himself?
I don't know.
It's possible.
For Forensics for Justice?
Yes.
I don't know.
Well, he raises funding, obviously. It may be local or foreign, you don't know.
I don't know. Not that I'm aware of. Or can recall, but I don't.
So then, this would then be consistent with your previous answer in paragraph 7. You say, after all these things you have said, and the 15 instances, you say, in view of the fact that the conduct of this person, meaning the accused, is bringing South Africa to its knees, we'll debate. We urgently request that the police to arrest and detain her.
Forensics for Justice.
Okay, so it was the short answer to that one. The judge was asking you is that it was in a representative capacity.
Correct. Thank you.
Okay. And then here comes the important part in respect to your other statements. And let me preface it with this. At least you were honest to the court about this. That at the beginning, you saw this, shall we call it, body of tweets.
Yes.
And it was concerning.
Correct.
And that's what sparked you, both in your individual and representative capacity, to go to the police station.
Correct.
Right. Some of those tweets were from the fake account, correct?
I can't recall.
I can. At the point where you went to the police station, you thought all these horrifying tweets came from the accused person, correct?
Correct. I can't recall.
Okay,
I'm sorry, I can't.
I'll remind you just now, don't worry. And not only did you think that they came from her account, you even went so far as to preempt. So you said, she's going to say it's a fake account and she's lying. You remember that?
Correct. So there was a statement, a separate statement about a fake.
No. Just answer the question. You said in your statement, not only are all these tweets from her, I know that she's going to say I was hacked or whatever, and it won't be true. It will be, actually you said it will be patently untrue.
I just want to say date.
It's the 13th of July.
Okay, so the accused
okay,
had.
let me take you out of a misery. Go to paragraph 8 of your statement.
Okay.
Can you read that out?
Finally, I note that she has falsely claimed that her Twitter account is a fake account. This is patently untrue and can be proven to be untrue.
So, do you now agree with that?
Okay, I
Yes. You said she's going to say it's a fake account and she'll be lying, basically.
it states she has falsely claimed.
Yeah, okay, whatever. But
It was
that
preempting.
is false, it's a lie.
Correct. I believe it's patent. This is, by me saying this is obviously I believe this is patently untrue and can be proven to be untrue. I have not proven it to be untrue.
No. Okay. Between the two of you and her, who was giving a false statement? She says, or she has said, the fake account. You say no. It turned out that you were the one who was saying something patently untrue, isn't it?
Okay. I'm not understanding. She said that there was a fake account.
What is it that you're not understanding?
You're saying that there was a fake account that was posting certain things, and that I'm saying that it was her account that
I
posted
never
things.
said anything about that.
So that's what
I'm saying, ma'am, and you understand the question, you're just dodging the question. I'm saying to you, you said in paragraph 8 that she has said her account is fake, and if she says that it would be patently untrue, in other words, false, so she would be lying. And so what's difficult about that?
Oh, it means her account. Oh, I see what you. Okay, yeah. Well, the question, please. Now that I understand what you're saying, I'm not.
Well, if you understand it,
So
you can
you're.
answer.
Let us please avoid talking simultaneously because we do not have, we are lost about what we are talking about. If perhaps for clarity, you mean Ms. Mbofi, in her statement, she said that the accused have said
Falsely claimed that her Twitter account is a fake account. It's patently untrue, can be proven to be untrue.
and where does she claim that?
At paragraph 8.
No, I mean the accused is claiming that to who? That her
No,
account
it's
is
not the
false.
accused, the witness.
Yes.
The witness says, finally, I know that she, meaning the accused,
Yes.
has falsely claimed that her Twitter account is a fake account. This is patently untrue and can be proven to be untrue.
I follow.
You follow. Thank you, madam. All right, again, we'll save time. If you don't want to answer the question, it's fine. But the point I really wanted to make was that firstly, Major General Governor has testified in this court that there were indeed 2 fake accounts which claimed to be the accused account.
Okay.
And you yourself, on the 16th of July 2021, found it necessary to go and do another statement where you referred to the fake account.
Correct,
Remember
my lord.
that?
I was. I think I was asked by one of the investigating officers.
Hello? Hello, I beg leave to end up a statement of Ms. Trent
Yes.
dated the 16th. Melanie France already have a copy. We'll call that G.
It's Exhibit G.
Oh,
Oh yes, we can make it
you.
C3, C2.
No, C2 is the
Oh yes, C3, yes, so that is in the C series. Thank you,
It's
Mr.
marked Exhibit C,
C3.
C3.
That is your signature at the end, correct?
Correct.
And that's the statement you made on the 16th of July.
Correct.
3 days after the first one, correct?
Correct.
And there you say that you put what you call the real fake Twitter account, which is the Sambudla one, and then you put what you call the real one, which is the Sambudla.
Correct.
Yeah?
My lord.
All right. So at this stage, you say that at least you accept that there was a fake account, correct?
Correct, my lord.
Yes. But you, in fairness to you, you then say at the end, the insightful message is sent, I'm reading paragraph 6, sorry, my lord. The insightful messages sent out by Zuma-Sambudla were sent out by her own genuine account. My complaint is not against the impersonated account. But the point I'm making is that at this stage you acknowledge that there's a fake account, correct?
Correct.
Right. And and the importance of this is this, ma'am. It's not about fake accounts or whatever. The importance of this is that at the initial stage, when you received all these tweets, you were not able, because you didn't think there was a fake account, you were not able to separate the wheat from the chaff, so to speak. So it was just a body of tweets, fake and genuine, all put together.
The tweets that I took were from one account. It wasn't from more than one account.
No, but okay. Let me put it this way. People, quote unquote, whatever the people are. All right. Then, just for the sake of completion, and I won't ask you much about this, there's another statement which you made on the 20th. Let's call it C4.
Statement is marked Exhibit C4.
As court places, my lord. That is the statement you made yourself?
Correct, my lord.
And
I don't have it, sorry.
Oh, I'm so sorry. Let me give it to you. C4. I'll mark it for you.
Thank you.
And that statement is a whole long thing about you being an association, a member of the Association of Certified Fraud Examiners.
Correct, my lord. I was asked to provide this statement.
You asked by who?
The state. And investigator. It was a long time ago, so I can't quite remember who exactly, but I didn't.
Sorry?
I didn't just think it up. I was asked to by the state. They asked me, "Can you please tell us about
Who
the
in the
investigation?"
state?
I cannot remember the name. It was one of the investigating teams early on, but I don't know the name.
Did they tell you why it was necessary for you to give this whole CV as if you are an expert witness?
I do not. I just know that it was days after that the case was opened, and perhaps they wanted this, but I believe that they've got experts, and they're not this. Perhaps they were considering me as an expert, but later on decided not to call me as an expert.
Yes. Well, that's understandable, isn't it? You can't be both biased and unbiased.
Correct, my lord.
And you are a biased person. I mean, okay, you have a person with an interest in this matter.
Correct, my lord. That's why to do an investigation, you need to be objective, and I had feelings towards it,
Yes.
and therefore could not do an objective investigation and have findings from both sides.
Yes.
Correct, my lord. And I believe that's probably, I don't want to assume why the state did not, but correct.
Yes, no, I was saying the same thing. You are not objective in this case.
Correct.
And in any event, your own CV says that for someone to be an expert, they must, I think I'm just going to take a random one. At patient 2, it says the person must demonstrate a commitment to professionalism, diligence of his or her duties, and not act unethically. I'm reading 5.1 and 5.2, paraphrasing, correct?
Correct.
And you would not fit that, your own standards in this particular case. I'm not saying generally you are a person who is not professional. I'm saying in this particular case you wouldn't fit that standard.
Correct. I wouldn't be, if I were to carry out an investigation, I would not be adhering to this. But as the complainant, I'm not, it's not in terms of these. Correct.
Yeah. So why didn't you just tell whoever it is that are you out of your mind? I can't be an expert in my own, and be a complainant in the same case.
At that time, I didn't quite know why I'd been asked for it. It was, I did say that. Not at the time. They asked me for it. For what purpose, my lord, they didn't say. It wasn't, they weren't saying, we are going to call you as an expert. They asked me to provide a description. It wasn't,
Yes, thank you.
I cannot, and I agree, I cannot give evidence in this matter as an expert witness.
And do you know any reason why this statement was also not revealed to the court?
I have no idea, my lord.
So,
I don't know, my lord.
thank you. Ma'am, I'm going to argue at the end. You may comment if you like, if you don't have to. I'm going to argue at the end that, firstly, your quality as a witness is very, very poor in my extensive experience. Any comment?
That's your opinion.
Yes. I'm also going to argue that you evade questions, especially when they come closer to the bone. Any comment?
I disagree.
Yes. I'm also going to argue that all your statements put together are not worth the paper they are written on, because once we interrogate them, whether individually or cumulatively, they come to zero.
I disagree. And the investigation will show whether there's a case or not. Right?
So, the investigation what?
Whether the state carried out an investigation, and their findings will result in whether we are in court today and the charges. Whether my statement itself, I made allegations, those were investigated.
No, I think I understand that. So, are you saying that, even if your statement comes to zero, it might well be that further investigations might have cured some defects?
Correct.
All right. And if those further investigations did not bolster the statement, then it is what it is, correct? Again, hypothetical. I'm saying if they found that there's something that corroborates, then obviously it would resuscitate the dead body like Lazarus in the Bible.
Correct.
Yes. But if they didn't find such bolstering evidence, then the body remains dead, correct?
Correct. Then there would be a decline to prosecute, I would say. There would be no prosecution, correct?
Or there should be no prosecution, correct?
I don't know.
No. If, ma'am, your evidence amounts to nothing and your complaint amounts to nothing, and nothing in the investigation resuscitates that, then there should be no prosecution. That should be obvious.
Correct.
Yes. This is not the civil court. We'll go to the civil court about malicious prosecution and political motives and all that. I'm just asking you just in the context of your statement. All right. And you agree, since we're on that subject, that if it is established, whether here or in another court, that this whole thing that has brought us here was politically motivated, it cannot be salvaged. It would be the fruits of a poisonous tree, correct?
Sorry, can you just repeat the question?
If it can be established that this entire exercise that has brought us here was politically motivated, then it cannot be at the same time lawful. correct?
I don't agree with that, no.
Do you think, so your evidence is that something could be politically motivated or have an ulterior motive and still be lawful? Is that your evidence?
I'm going to answer this as how I understand your question. A criminal offence is a criminal offence. So you and I know that you've committed a criminal offence and we have a fight. I'm going to say, I'm going to get you back. I know that you committed this offence, so I'm going to go and open a case. My reasoning and motive for opening that case does not take away from the fact that an offence was committed or a suspected offence was committed. So whether it's politically motivated, I can't say why the charges were brought. The state must show why the charges were brought or the accused was charged.
No.
But the reason for that, whether it's politically motivated or not, does not take away from whether there's an offence or not.
Okay. Fair enough.
Did I understand your
No,
question?
I understand you. But you agree that, let's forget about the state, as I say, we'll deal with the state in another forum. From your point of view, as the initiator of all this, you and Mr. O'Sullivan, if you were motivated by malice and political motives, that would taint the entire process, correct?
Incorrect.
So whether you
Again,
are doing this
if
because you
I-
hate...
My lord,
Your colleague is on his feet.
my colleague has raised what essentially is a collateral issue. And the witness has said that is incorrect. In other words, she has disputed the point raised by my colleague. It is a matter for another day about whether it's politically motivated and how that affects. This is a criminal trial, and the issue here is whether the accused made certain statements or not. And if the issue is whether the statements made by the accused are insightful or not. All the other issues of malicious prosecution and all is another issue for another day if we get there.
Thank you, Malena. Well, I thank my learned friend for repeating what I said, that those issues will be in another forum. But back to what we're busy with, it's not collateral, the issue of political motivation. I read it out to the witness yesterday. I handed up the statement to her and the court this morning, so I don't know when it becomes collateral. But in any event, ma'am, I was really in the mode of putting things that I'm going to argue, so I shouldn't really take you further.
So simply what counsel is suggesting is that during address, that would be looked at whether it constitutes fairness or unfairness of the trial.
Yes. In other words, ma'am, to put it shortly, I'm going to, and you can comment if you want, I'm going to argue that the evidence, your evidence, displays that this whole thing started from malice, and it was politically motivated on your part, Mr. O'Sullivan, Forensics for Justice, and so on. What is your comment?
I disagree, my lord.
Okay. And finally, I will argue that the only reason that you became this busybody is not because you were concerned about the things that you were concerned about, but it was because of her and her father, and it was politically motivated in that sense as well, because you were targeting her because of who she is, and more tragically, who her father is.
I disagree, my lord.
As God pleases, my lord, I have nothing further.
Thank you. I don't know, Mr. Kangai, whether we'll now have to adjourn for T's 5-2 or you want to continue now.
My lord, I think a tea adjournment would be good. It will help me refine my questions so that we agreed that we were going to stop at 2 and we would take one break. So
Not stop at 1 o'clock today.
At
What
1
did
o'clock.
we say?
We said, my Lord,
Because I understand.
we said 2.
Oh, 2 o'clock.
Yes, my Lord, if I may just appeal to the court,
Yeah.
because we just had a quick discussion, so Your Lordship might not have gone. Depending of course how long my learned friend is going to be, him and I had agreed that since we had agreed on one break, because he said he needs a break between this witness and the next witness.
Oh, I see.
So if Your Lordship could kindly allow my learned friend to do the re-examination, so that that one break can also serve for him to.
So you agree, Mr. Kangara?
My Lord, I agree with the one break concept. I don't have an issue with that. But I would also, I do have many questions in re-examination, and I would like to streamline them so that we can deal with the re-examination as quickly as possible. I will use the break also then to consult with the next witness, or to just finalize my consultation with the next witness.
Then you can proceed with the cross-examination. I'm sorry, re-examination, if that is how you feel. Is that how you feel?
My Lord, let's do the re-examination as far as I can go, and then we will take a decision.
Thank you, may proceed.
Ma'am, I want to deal, you were pointed out to paragraph 6.1 to 6.4 in the cross-examination.
Correct,
You
Madam.
recall you were pointed out to those 4 posts collectively, and it was suggested to you that those posts could not have been about the issue of the incarceration or the imprisonment of the former President Jacob Zuma, because it had not happened. That happened on the night of the 7th to the 8th. Do you recall?
Correct, Madam.
Then I just want to that although Mr. Zuma handed himself over to the prison, although he handed himself over to the prison authorities on the night of the 7th to 8th, the issue of his imprisonment became an issue on the 29th of June.
Correct, my Lord.
Right. And
Correct.
so, now that you know that the issue of his imprisonment came about on the 29th of June, and he only handed himself over, the fact that some of these posts deal with the imprisonment, do you find that unusual as you answered previously?
Sorry,
Do you still find it unusual that some of your posts deal with the fact of his imprisonment, knowing now that it happened, the discussion started of that issue on the 29th of June?
correct. His imprisonment was known from that time.
There were some days before the court made the decision and before he handed himself
Correct.
over. Correct. So, right. Okay, I just wanted to get past that before I forgot those particular things. Now, ma'am, I'm going to start to deal very quickly with the issue of your 4 statements, because it is an issue that I am partly responsible for. It is correct that you made 4 statements in this matter, correct?
As far as I can see,
sorry,
3.
3 statements and with the annexure, right? C1, C2, C3, C4. C1, C2, C3, which I handed in today, and C4.
Correct.
Right. Now, I just want you to focus, you were given copies today perhaps of C3 and C4. Okay, then.
Only C4 is
So
marked.
C4 is your CV.
Correct.
Right. Now, do you make any allegations against Ms. Zuma in C4?
I do not know.
That entire statement is about you, correct?
Correct, Madam.
It is about your qualifications and your experience, not so?
Correct, my Lord. It describes what is certain
Your qualifications,
certain
your
information
training.
about what a certified fraud examiner
So again,
is.
you are talking spontaneous.
Sorry,
I
it's my
apologize.
apologies. I think it's my fault. my Lord.
If you can just, I know that you are eager to answer, but if you can just be patient,
Apologies.
once the counsel is done with the question, then respond.
Okay, sorry.
Thank you.
Now, ma'am, just so that we have it on record, probably C4, the one that you have with you, it was given to you earlier, the one that hasn't been handed out. That is basically your experience, your qualifications, and somewhat of a CV of yourself, right?
My Lord, I was asked about what, if I recall, this is only about the Association of Certified Fraud Examiners and a description of, for example, adhere to code of ethics, academic requirements, professional requirements.
Ms. Tran, the question from, he's your own counsel. He's your own counsel.
Yeah.
The question from your own counsel is whether the CV is just about yourself.
Oh, yes, correct. Correct,
Right.
my Lord.
You do not implicate the accused in this,
Correct,
and
my
so
Lord.
it or say anything about it, correct?
Correct, my Lord.
Right. Now, you said you made a supplementary statement which we had entered into the exhibit as C3.
I'm sorry, it's not your own counsel, I must correct it. It's the state counsel. So for record,
Understood, my
for
lord.
record, it's not your own
My Lord, I
counsel,
didn't,
it's the state
because he said
counsel.
CV, I didn't want to
No,
say
don't
it was my
don't worry
CV.
about the CV. I'm correcting what I've said. Your own counsel is the state counsel. Thank you, may proceed.
Ma'am, this is the statement that is dated 16 July 2021. Do you have a copy?
Yes, correct, my Lord.
It is the one that says, I, the understand, if you look at paragraph 3, it says on 2021-07-08 at, inverted commas, at Zuma-Sambudla, and it goes on and there's a picture. Can you see that same?
I see
Right.
that, yes.
Now, ma'am, you recall making the statement, correct?
Correct.
All right. In this statement, do you implicate Ms. Zuma in any way further, or do you clarify certain issues from your first statement?
My Lord, for the first, you asked me two questions in the.
Right.
In
Do you
one.
implicate Ms. Zuma? Do you add any further posts or anything to say that she further committed these offences?
No, my Lord.
What was the purpose of making this statement?
It was to. I'm trying to think. The purpose of this statement was. The state asked me to. I'm just trying to think what the. I received a request about something about a fake account. I then made the statement.
And maybe one
And-
has-
So just a moment.
I'm sorry.
Can let's hear her. She's saying she received something about fake account and then proceed and finish and then continue. Yes. The question was, what was the purpose of
of the
this
statement.
statement? And you say you received something about fake account. Then, if you can complete that.
I received from the state a query as to a fake account. Now, forgive me, I can't recall exactly what this was about. And so I drafted this. And I'm assuming, my Lord, that the state would have considered this, whether it was relevant or not. But it doesn't make any allegations
You said it does not make any allegations
against the accused, correct? Hold on.
Now, ma'am, you were asked, and I just want you to clarify. You said that indeed the accused did have a fake account, correct?
Sorry.
Ma'am, can you follow the question that I'm asking you, please?
Pardon?
I'm done with that document. When under cross-examination, you conceded that the accused did have a fake account.
Great. There was an account that seemed to be impersonating the accused.
The question might have been put to you pertinently. I might have missed it because I cannot recall your answer. But the posts that you put in C1, those video clips that we've been going through and watching in court and all of that, did they come from did any one of those come from a fake account?
No. No, my lord.
Yeah.
But again, this is not a big point, but just from a professional point of view, I don't know if my learned friend wants to revise his theory, because I'm sure it's not his intention to mislead the court when he says that the statement C3 does not make any allegations. Because in paragraph 5 it says, Ms. Sambudla does claim that the reality account is an account impersonating her. She failed to report this account and unlawfully and intentionally allowed incitement in her name to more than 100,000 followers. If that's not an allegation, then I don't know what an allegation is.
Yes, Mr.
My lord, that is particularly why I asked the next set of questions. Because even if there were inciting statements in the fake account, my point was to establish that none of those form the subject of this trial.
Yes.
So I'm sure my objection is not understood. All my learned friend has to do is just to retract the false allegation he put to the witness. I'm saying, when you say to somebody, you say you have a fake account, but in any event, you failed to report this account and unlawfully, and therefore unlawfully and intentionally allowed incitement in your name to more than 100,000 followers. Whether that's true or false, that's an allegation you're making to a person.
So the issue that you are raising, Mr. Mpofu, is that the submission by counsel for the state that this statement does not implicate Ms. Sambudla Zuma in any way is incorrect.
That's correct.
Perhaps I'll rephrase my question. Ma'am,
Yes.
does this statement implicate Ms. Sambudla Zuma in any way in the trial proceedings that we're busy with now?
No, my lord.
Thank you.
Well, we'll leave that then for...
Thank you. Would you agree then, my lord, would you agree then, Ms. Trent, that these statements, insofar as this case is concerned, take the state's case no further?
Correct, my lord.
Now, you were given an exhibit during cross-examination, Exhibit F.
Sorry,
Exhibit F is that pamphlet and invitation to the Women for Change.
I see that.
Now, I'm just going to suspect the reason that you were given this was to draw some kind of comparison to the photograph that calls for the shutdown of KZN and to demonstrate that it necessarily does not call for violence.
Sorry, can you repeat that?
I think the problem is you must listen to the question rather than focusing on the exhibit.
Okay.
I'm sorry, I'm not fighting with you. I just need us to understand each other. Otherwise, we're going to be here for a very long
No,
time.
no, all what counsel for the state is saying is that be patient, wait until he's finished with the question and then respond.
Ma'am, you were given this Women for Change, Women Shutdown today.
Correct, my lord.
Is there any violence or unrest or burning of cars or blocking of roads or anything happening outside in the country at this moment that makes it similar to the time when you received the shutdown notice that is in paragraph 6.6 of your affidavit?
No, my lord.
All right. So, ma'am, you today commented on Exhibit F, and you said that it didn't appear to promote violence in any way.
Correct, my lord.
Had you received it in a circumstance where people were striking and looting shops and blocking roads and burning tires and doing all things for days on some issue involving women, would your acknowledgement of this pamphlet be in exactly the same as it is today?
No, my lord.
What would it have been in such a circumstance? Let's speculate.
Sorry?
How would you have received it with that background?
I probably would have interpreted it differently, or the motive for behind the, what it was going to be for, and the purpose of this. For now,
Right. So what I'm trying to establish, ma'am, is the background at the time that you received these videos and messages and that you viewed them, the background in the country at the time, just correct me if I'm wrong, but General Governor said that there was a nationwide, particularly KZN in Gauteng, there was chaos.
correct, my lord.
Roads were being blocked.
Correct, my lord.
Buildings were being burnt.
Correct, my lord.
Factories were being shut down or burnt.
Correct.
Shops were being shut down or burnt.
Correct.
Governments were being shut down or burnt, or if there was a test.
Correct.
Right.
So, my lord, what governments were being banned?
Government buildings, my lord, but perhaps that is information that I have in respect of another matter, and I ought not to have raised it here.
Yes,
I will withdraw that question.
So it's belonged to another matter.
My lord, I've
So
dealt with about
you
17
withdraw.
unrest matters, and I have a lot of information.
So you withdraw that.
I withdraw the issue of government at this point. So
Yeah.
thank you, my lord.
the point,
It's a second one, my lord. If my learned friend wants to testify, he must go that side. That's a question.
Is already withdrawn.
if it
Continue.
becomes necessary, I will exceed my colleague's request. Right. Now, ma'am, would you agree, sorry, we were talking about that. So, the situation in which you received a thing played an important role into how you interpreted it.
Correct.
Now, today, as you sit here and you are shown a video of a group of people armed, or you watch a video of a group of people armed with traditional weapons celebrating in front of a store, as opposed to in the middle of the July unrest when all kinds of violence and unusual things were taking place. Would your reception of such a video be the same?
No.
What would your reception of such a video be informed by?
But I'm sorry, I'm a bit tired.
All right, let me move on, ma'am. I think I have made my point.
So there is no answer for that.
There's no, I made
No,
the
if you
point.
could just say the question again.
I didn't forget the question.
Sorry.
I said, would your reception of the video at Spa in Matubatuba, the court correctly described it as that is the Amabuto celebrating out on a weekend, enjoying themselves.
Correct.
Now that you know what it is, you know what it is.
Yes.
But in July, when you received it on the 9th between the 9th and the 17th of July, and the situation in the country was where people were doing exactly the same thing in a more violent context. Did you receive it the same way?
Correct, and it was in between other posts.
Now, ma'am, this violence that was going on and this blocking of roads and all of these things and tires burning on the road, were you only seeing it here on Zuma-Sambudla's Twitter account, or were you also viewing these things elsewhere?
Also viewing things elsewhere, yes.
Where were
It was
you?
in the media.
Was it on television?
Yes.
Right. So the situation all around you was a violent one, correct?
I'm counting now. This is the 15th leading question. Counsel, when questioning their own witness, is not allowed to do what Malama friend is doing. It's only done in cross-examination. Who's testifying here?
Just
the
a
witness?
moment.
All she's saying is correct. But he's giving the evidence.
Mr. Kangai, I'm sure you understand that the purpose of re-examination on issues that arise from cross-examination if we can just focus on
My
that.
Lord, I mean, this is the court for the reminder of the purpose of re-examination. I did say that I would have curtailed my or narrowed it down had I had the opportunity to prepare it. And I'm trying to prepare
No, that you have said, I understand.
and present it at the same time. And so what I'm trying to do, instead of going through each one and saying, what did you do when you saw this photo? I'm making a global picture.
No, thank you. Then proceed with your examination with that understanding, with your re-examination. Thank
And
you.
my Lord, it is not true that the witness said correct 15 times, because she answered many other answers to questions, including that she saw it on TV, which is not correct. Now, ma'am, I just want to turn you back to paragraph 6.4. No. Lord, if you bear with me a moment. And then I want you to look at exhibit C2. To look at exhibit C2 on page 13. Do you have it?
I do,
Page
yes.
13? Right. Now, ma'am, it is correct, as my colleague put to you, that, or my colleague suggested to you, that you said that this video was recorded on the 5th of July. In cross-examination that was put to you.
Sorry, I don't know when it was recorded. It was posted on the 9th of July.
Oh, sorry.
If I'm looking at the right...
I'm sorry, posted. It was posted. It was put to you that this was posted on the 5th of July and could not...
This was on the
have-
9th of July, 2021. If I'm looking at the correct, on page 13, the screenshot of the video.
Yeah, if you look at paragraph 6.4 of C1 and compare the photo to page 13,
Yes, yes.
that was on the 9th of July, correct?
Correct, my lord.
Right, so that was already when Umkhonto Wesizwe Zuma was at escort correctly placed, correct?
Correct,
That is the Moy Plaza video,
correct.
or what we refer to as Moy Plaza. As for please, my Lord, I have no further questions to the witness.
Thank you. Just one issue for reason.
My Lord, yes, I'm sorry, my Lord. This is, before your Lordship ask the question, just for my own clarity,
Yes.
just because it might be my fault, maybe I recorded this wrongly. My understanding, my Lord, if you go to 6.4, it is one of those where the witness said she had unfortunately or inadvertently omitted to put the date. It just says 07/2021, but there's no date. You see that, my Lord? Just under 6.4.
Yes.
Yes. Now, when my note says that when she was then asked in chief what that date was, she gave 5 July 2021. Am I wrong? I just
My Lord,
want to-
I agree with my colleague in what he said.
Yes.
I then referred the witness to C2 and asked her to read out the date from there, and then she corrected the date to the correct date.
All right. Thank you. No further.
I have nothing further, my Lord. I have covered all of the items.
Thank you. Just one issue, if not few, from me for clarity. You said what gave rise to you deposing to the second statement was a query from South African Police Services.
Yes, it seems to be the case. There was a, as far as I understand, I don't know if it's how they investigated, if there was a unit that was investigating, and there was a request for me to give a statement on something, not as an expert, but relating to my A1 statement.
Lord, just for correction so that we don't fight when we get the record. You referred to C2.
Yes, is it
And
C3?
C2 is not a statement, it's an annexure to C1. The statement, I know that I had made the same mistake, my lord, but actually what my lord
Oh,
is
sorry,
saying is
C3. C3. Thank
Yes.
you. Thank you, Mr.
I didn't want to have to argue later about that.
Thank you. Yes, you may proceed and explain that.
Yes, and that's what I recall. Perhaps the state can. There was an email.
What
I
did
can't
they?
recall.
What did they require you to clarify?
I don't recall
So,
what.
in short, why I ask this question? It's I would like to know that after, because you are the complainant,
Yes.
after submitting your first statement to the police, did you then continue with investigation of the matter? What happened? Who was investigating here?
No, my lord, I didn't continue with the investigation. I received a request. I do not know why I was asked to do a further statement or to give the credentials. I just gave it to them. I didn't continue in an investigation, my lord.
I'm sure both counsel, state and defense counsel will understand where I come from, because where I look at C3, it says, Duduzile Sambudla Zuma has to date never denied that the Twitter account is hers, nor has she claimed that the said account is impersonating her. In the event that Duduzile Zuma-Sambudla does claim that the really Twitter account is an account impersonating her, she has failed to report this. All what I want to inquire is, after, that's what I wanted to inquire from you, is after reporting this matter, did you continue to investigate, find further facts whether she was lying or not, or then you left it to the police to continue with their investigation? As it is appear here, I want just that clarity from the witness.
Indeed, my lord, but I appreciate the issue and I will deal with it through other witnesses as well.
Thank you, but I want answer from that witness.
I didn't go and continue an investigation, my lord, but I can't recall why it was asked.
So you don't have an answer why they ask you
I don't.
to
To
gather that information from them.
If I could be reminded of what was asked, I would be able to answer.
I'm in the dark because I rely on what is before court. That's why I wanted to clear that. No issues.
Perhaps-
No, wait,
Yeah, sorry.
Mr. All what I wanted to know is to clarify this issue in order you're involved with investigation or you simply late complaint. That's all.
Okay,
Any
nice.
issue arising from examination by court?
Nothing from the state, my lord.
Yes, my lord. Just two things. You understand what the lordship was asking and why, because he explained it, correct?
Correct.
Your answer is that you cannot recall how the statement came about, correct?
No. What was asked of me?
Just please, ma'am. Is your answer that you cannot recall how the statement came about?
Oh no, I do recall that I made the statement.
No.
There was an.
We've established you made the statement, your signature is on
Yes.
it. That's not what I'm asking you. I'm asking you that you cannot recall what gave rise to the statement.
It was to do with a fake account. It could have been because of something I said in my A1.
Okay, let me make it easier. If you cannot recall the circumstances, it's possible that you yourself, having read your statement, you subsequently, 3 days later, volunteered this information.
It's possible, my lord,
Yes.
but not carrying out an active investigation.
No.
But it may have come to my attention and me thinking, oh,
But
you know,
me,
or yeah, that's
yes,
it's possible.
no,
Correct.
it's possible
correct.
is enough. Once you've said you can't be faulted for saying it's possible. So that's really the gist then of the question. That it's possible that you yourself, nobody asked you, and you felt that you needed to bolster the case or whatever.
It's possible.
Yes.
It's possible. I cannot recall. It's possible. Yes, that's my answer.
Yes, and I'm going to argue that that possibility is the more probable one because of the wording of your statement. Because it says, in the event that Duduzile Zuma-Sambudla does claim that the real Twitter is an account and so on, it can be some policeman was just sitting. What if she claims that? So that is you clearly now wanting to, and there's nothing wrong with it, wanting to, having found this fake account, wanting to correct the
Simply supplement.
supplement, yes. And not only supplement, but correct the strong impression you had created in the first one that if she says it's fake, she should be lying. So it would be a point in your favor that you wanted to come clean that actually I've now found a fake account.
So to
Possible.
come clean.
Yes, remember the debate you and I had?
Yes.
That at some point you said she was lying about a fake account. Then obviously...
Oh yes, correct, correct.
So
It was a
obviously at some
supplement.
stage you discovered that there was a fake account and you were coming clean in that sense. No?
Supplementing, correct.
Yes. So then that's what we mean. I'll argue then that that constitutes, or that is tantamount to you conducting further investigations for better or for worse, and then supplementing your statement. Agreed?
If that's your, I disagree that it's active.
He's just putting that to you. You agree or not?
You've just put it to me. I disagree.
You disagree? What is it? So, okay, sorry, let me try and help you. It's not possible, you have now said, despite all that we've agreed on, it's not possible that you, sitting at home on your own, thought, oh, I've said this, let me go. I've now found that there is a fake account, let me go and do another statement. Is that not possible?
Yes, yes, it is possible.
Thank you.
Miss Strand, I wish to thank you for your time. It has been a long day for you. Since yesterday and today, you are now done. Thank you. You may step down.
Thank you.
Will
My lord, it is now 11:30.
yeah.
I anticipate that I would need about an hour with my next witness. Shall we take a break between now and 12:30? And if I'm ready, I will call the witness in that stage.
So you'll need an hour.
I anticipate, my lord, there's a few aspects that I need to go through with the witness, including the expert reports that we received from my colleague, which I have the witnesses had sight of, but I've not discussed with them yet.
Well, in the light of what then the state is saying, keeping in mind that Mr. Mbofu also have to leave by 2 o'clock for an SCA matter, if we adjourn for 1 hour now, when do we come back? Is it necessary then to come back to
My lord, I actually did suggest that we end proceedings now and we continue next week, but my colleague was quite insistent that we continue.
Mr. Mbofu?
My Lord, yes. Well, the my friend is disclosing discussions between us, but that's fine.
No, I'm just asking. I don't want to
Whether you have
get
to come-
involved in
no,
one.
I won't go into that. Yes, no, my lord, the arrangement is that my learned friend had said actually he was going to need half an hour or so, but I don't fault him if he has increased that to an hour. But the point, my lord, was that in the interest of speeding up the trial and not wasting time, was my understanding was that the arrangement was that the next witness would be called to testify in chief. Obviously, I won't be able to just examine today, and that's the arrangement. So, I'm sorry, my lord. I apologize to the court
I
first.
apologize, my lord. Shall we not, would it not be better if we were just postponed until Monday?
No.
All right, in the light of what is being said, I'll give the state 1 hour to consult. Then now it's 11:30. We'll come back 12:30.
After 12 is not
Is that now suitable? Does that suit?
suitable to the state.
Let's continue.
Then we'll adjourn for 1 hour until 12:30. Court will rise.
because ngiyabona from